talking about progress, it is not measured by how fast the nation is growing. It is also measured by whether a girl can attend the school without being punished for her biology. And for the longest time in our country, menstruation has not just been a health issue for girls, it has been an educational barrier. And because of this barrier, the first casualty was dignity. And this recognition has been finally taken up by our apex court, where they have labelled that menstrual health is a fundamental right. It is your right to dignity and we cannot take it off from the menstruating people. Hello everyone, welcome to Vajram and Ravi's Flash News. My name is Shubhangi Singh and in today's session, we will be looking into that what exactly Supreme Court has mentioned as a fundamental right, what are the directions that they have given, what is the framework that have been laid out, and what can be expected out of this very important change that has been finally brought up. So let us begin with looking into that what exactly has Supreme Court said. The Supreme Court has clearly gone out and told that menstrual health is a fundamental right, and furthermore they have given clear directives to ensure that the accessibility to menstrual health, hygiene, sanitation is available across the country. Now when we are talking about this direction has been in response to a PIL which was filed in 2024, and when Supreme Court declared that right to menstrual health and also access to menstrual hygiene management is something that is part of right to dignity, right to life. It is part of Article 21 of our Constitution. Supreme Court has also highlighted that dignity is not something that is an abstract idea and it must be given to individuals so that they have to live without humiliation, exclusion or avoidable suffering. And this is where they have highlighted that menstruating, especially girl children, and their inaccessibility to menstrual health management measures not only subjects them to humiliation but also stereotyping and stigma. Now as a result, when we are talking about Article 21, the scope here has been expanded and it has not only addressed dignity but it has also addressed gender justice in this particular scenario. Now in this whole judgment, Supreme Court clearly emphasized on dignity of adolescent girls. They also emphasized on equality in access to education and also most importantly breaking the silence and stigma that is present around menstruation. So menstruation, which was a social stigma, that was a taboo topic, has now become a constitutional right which will be talked about. There will be public awareness and that leaves not only dignity with the menstruating girl children and menstruating women, but also it brings gender justice to an extent. So here we also get from the perspective of exam, if you see, here we get to see expansion and also explanation of Article 21 from a very gender sensitive lens, also gender sensitive constitutional interpretation, which is very important for our constitution, because when we regard it as a living document, it is because of the lens through which it is seen. And in this context, this becomes a very landmark judgment when we are looking at a progressive society. Now, when we are talking about this judgment, it also becomes important for us to look into that what are the specific directions that have been given by Supreme Court to actually ensure that menstrual health management measures are carried out across the country. When we are talking about directions, there have been nationwide directions that have been given. First has been the one where free oxo-biodegradable sanitary napkins will be given to all girl students, and the applicability here Supreme Court has given will be for government schools, private schools and also urban and rural areas. Apart from this, when we are talking about this mandate, there has been a specific legal nature. Apart from this, there has been a direction for private school as well. If there is non-compliance seen by private schools, they will be de-recognized, and the directions which have been given by Supreme Court have to be applicable, they have to be implemented within 3 months itself. Apart from that, there is a direct directive for mandatory segregated toilets for girls and boys. Also, disabled friendly toilets. And these toilets are supposed to have not just functional water, taps, soap, but also privacy and waste disposable systems. The Supreme Court has given a clear guideline that the dustbins or the disposal system should be permanently covered so as to ensure safe waste disposal. So you will be able to understand that how clear has been the Supreme Court in all of these guidelines, so as to ensure that the implementation happens because of the clarity and there will be faster implementation. Now, when we are talking about these directives, they hold a very special legal nature in this context because they are not at all advisory, they are binding, and these are binding under Article 141, where a law made by Supreme Court is applicable as a law across the country, which ensures consistency. So, based on this article, these are binding and mandatory, and union government will be responsible for monitoring compliance. Supreme Court has given the directive, they have made this particular guideline, and this binding law needs to be followed, and the compliance will be looked into by the executive, which is the work of executive. So, here you are not only getting to see judicial activism, you are also seeing that there is enforceability of socio-economic rights which is coming from Supreme Court's end. Furthermore, Supreme Court has also established that what kind of sanitary napkins and what kind of environmental compliance will be followed. Supreme Court has asked to put up proper sanitary vending machines inside the toilets so as to ensure proper accessibility. And when we are talking about union government looking into the compliance, it is going to be district enforcement officers which will be ensuring with regular audits and fulfillment mechanism. So, Supreme Court has given a very holistic directive to ensure that menstrual health is something that is taken very seriously by the educational setup so as to ensure that there is no loss to menstruating girl children. Now, in this context, it has not just been in terms of vending machines and sanitary napkins, but there have been a directive about infrastructure also. As I mentioned, that Supreme Court has asked for separate toilet for boys and girls, there will be disabled friendly toilets, and toilets must ensure not only privacy, but water connectivity and functional hand washing with proper soap. You might be thinking this is something very basic, will be found everywhere, but really not. If you look at rural areas, this is something that would be counted as a rare thing and mostly missing when we are talking about government schools because of the limited funds and facilities which are present there. But government has to ensure that this does not remain the scenario and the scenario changes in the coming time. Other than that, as I said, for the accessibility of the menstrual products, the sanitary pads have to be environment compliant based on the given standards, and they will be dispensed through vending machines, and furthermore there will be proper sanitary waste disposal mechanisms which will be set up. So, there is end-to-end insurance, and this is to be implemented through the whole educational framework. That is why educational reforms have also been talked about, where NCERT and SCERT, they will be the one to ensure that they talk about, that they bring in menstruation and puberty into curriculum so that it is not something that is a taboo, a stigma is associated with it, and furthermore include reproductive health issues like PCOS, PCOD in the curriculum, and focus on stigma-free, gender-responsive teaching and pedagogy so that the stigma, taboo around it is diminished gradually in the coming times. Apart from that, when we are talking about educational reforms itself, we also get to see there has been a conversation about teacher sensitization. That means there will be a mandatory training for male teachers and also female teachers to ensure that these educational reforms are also brought in. So teachers will be the one who will be supporting the menstruating students so that they do not have to compromise on their dignity, they do not feel left out, excluded and humiliated at all. Now many of you might be thinking that why is this being dealt in so much detail by Supreme Court? Why menstrual health is being treated at a priority? It is being treated as a priority because it costs our country human capital, it is costing our national productivity, because when you look at the numbers, you will find that 20 to 25% of girls miss their school during menstruation. There is a high dropout rate, especially when you talk about menarche, that means when the menstruation begins for girls. And when you are talking about female labor force participation rate, it is only around 25%. That's why we get to see learning disruption for girls, which leads to a skill deficit. We also get to see reduced female workforce participation. And when half of the population is in the skill deficit or is limited because of this particular problem, then the long-term GDP loss will be at our hand because we are not utilizing our human capital to the maximum potential. So what we get to see that if a country is neglecting menstrual health, it will directly lead to a structural economic problem that will create inefficiency. So this is something that should click into the mind, that when we are talking about health, we are ensuring economic productivity also. If somebody is not getting the idea of dignity, they might be able to catch on the idea of economic productivity itself. And when we are looking at a Viksit Bharat, it talks about inclusive growth at its foremost agenda, but that wouldn't be possible if we are leaving out half of our population and we are not focusing on their human capital formation. Now let us try to understand that how does this judgment actually bring strength to not only gender justice but also public health. Now for this we need to understand that there are serious health consequences of poor menstrual health hygiene. If this is not maintained, then there will be problems such as reproductive tract infections, urinary tract infections, increased maternal health risk and also greater burden on health system. So if we want to reduce the risk of infections, we want to reduce the burden on public health, then we need to ensure that menstrual hygiene is not poor, and that can be done only with ensuring awareness, only with ensuring accessibility and also menstrual health measures that would be taken so as to ensure that this is not the concern. The accessibility, the awareness is such that poor menstrual hygiene is out of the picture. Apart from that, you also need to understand that gender justice dimension here is way broader than you think, because when we look at menstruation, it is seen as just a biological reality, something that you cannot separate from yourself. And it is also seen as a simple social disadvantage. But you have to understand that it is not as simple as just labeling it, because this also reinforces dignity, it also reinforces equality and substantive justice. In this context, it is very important to remember that we don't want this disadvantage, the biological disadvantage, to cost us socially, to cost us economically as well. And that is why this particular Supreme Court directive is not just important for public health but also gender justice. Now this verdict that has been given has been an exemplary interpretation of Article 21, but it was not just Article 21. It is an exemplary verdict when we are talking about environmental, federal and also policy dimensions, because this is where we get to see absolute good environmental governance also in play. How? When we are talking about mandatory use of sanitary napkins or vending machines, it has been labeled that they will be biodegradable. What kind of environmental compliance, that also has been assured. This addresses the plastic waste problem. This addresses the urban waste management challenges. It has also a federal dimension associated with it, because when you talk about education and also health, they are the state subjects. So the possibility of confusion, ambiguity, state subject, union subject, that has been taken away, and there will be nationwide implementation of this policy. Still after that, Supreme Court has ensured that union will be responsible for nationwide compliance, and this is a very good example when you are talking about a case study, when you can put up cooperative federalism with accountability without compromising on legislative powers. And this is also where we see a very good alignment with the policies of present. For example, new education policy of 2020, for example, Swachh Bharat mission, for example, menstrual hygiene policy, and also the adolescent health programs which are running. And on this note, I will be ending with the thought that this Supreme Court verdict is not just a landmark verdict, but when it has given recognition to menstrual health, this is where Supreme Court has made a constitutional investment in India's human capital, and the dividends are going to be received by India's society, India's economy for far and long. What are your thoughts on this? Let me know in the comment section. That was all from my side. Thank you so much.